Thank you, Professor Tamase. The Dean of the UP College of Law, Dean Darlene Marie Berberabe, the faculty of UP Law, members of the George Malcolm Foundation, headed by its chair, Justice Tony Carpio, former Chief Justice Hilario Davide, retired Ombudsman Conchita Carpio Morales, Attorney Joel Raymond Aison, President of the Philippine Bar Association, incumbent and former members of the court, fellow members of the Integrated Bar and the ACA team, students and friends, good morning. Today we will rise to the question of necessity or the benefits of having an absolute divorce law. As lawyers, the first question that we need to discuss is constitutionality. Sad to say, many discussions on divorce, although important, focused on necessity and benefits like being in an abusive relationship, economic abuse, or having irreconcilable differences. Yet as lawyers, we were taught that the fundamental question is the law constitutional? Constitutionally, or constitutionality, therefore, precedes necessity or benefits of a bill. Thus, if the proposed divorce law is passed by Congress, the question is, does it violate the present Constitution? Article 2, Section 15 of the Constitution states, you may read it, marriage, as an inviolable social institution, is the foundation of the family and shall be protected by the state. The critical word is inviolable, which means cannot be broken or cannot be violated. If we follow the verba legis rule or the plain meaning rule, there could be no divorce under the present Constitution. However, divorce proponents will invoke the framers' intent. They will cite the question of the late Jesuit constitutionalist Father Joaquin Bernas to the late Constitutional or Human Rights Commissioner Chito Gascon, whether the provision which aims to strengthen the family is to ban an absolute divorce law. Under the intention rule, divorce proponents will argue that there is no prohibition under the Constitution, but it was not the intent of the framers to ban absolute divorce. I would like to navigate the discussion on these premises. First, verba legis is the rule, ratio legis est anima, or the intention rule, is the exception. First, in the House of Representatives versus Francisco, our Supreme Court gives a guideline on how the Constitution or the law is interpreted. First, verba legis, that is, wherever possible, the words used in the Constitution must be given their ordinary meaning, except where technical terms are employed. The court said, we look to the language of the document itself in our search for its meaning. The words are to be given their ordinary meaning, except when technical terms are employed, in which case the significance thus attached to them prevails. Second, where there is ambiguity, ratio legis est anima. The words of the Constitution should be interpreted in accordance with the intent of the framers. The court said, the object is to ascertain the reason which induced the framers of the Constitution to enact the particular provision and the purpose sought to be accomplished thereby, in order to construe the whole as to make the words consonant to that reason and calculated to effect that purpose. And third, ut magis valeat quam pereat. The Constitution is to be interpreted as a whole. The court said that we think it's safer to construe the construction from what appears upon its face. The proper interpretation, therefore, depends more on how it was understood by the people adopting it than in the framers' understanding of the law. Now, having these principles in mind, let us go back to Section 2, Article 15. Again, marriage as an inviolable social institution is the foundation of the family and shall be protected by the state. Section 2, Article 15 gives two constitutional safeguards against a divorce law. First is the word inviolable. And second is the phrase, shall be protected by the state. Inviolable describes the social institution, that is marriage, which are likewise to be protected by the state. Let's ask ourselves, is there something technical or ambiguous in the said provision? Is the word inviolable technical or ambiguous to justify interpretation or construction? I have consulted and read different dictionaries. You may do so, you may Google using your smartphones. And so far, there is no meaning or interpretation of the word contradicts one by the other. In plain, simple language, inviolable means to uphold, to preserve, to defend, or to hold sacred. These are dictionary meanings of the word. Hence, the term is not ambiguous, it's not technical. It is not capable of two or more contradictory interpretations. The second constitutional safeguard is the last phrase of Section 2. The Constitution mandates that the state should protect marriage. Interestingly, the Constitution did not distinguish whether the state should only protect working or abusive marriages. It simply says marriage. And since there is no distinction, neither should we distinguish a failed from a successful marriage. Where the law does not distinguish, the courts should not distinguish. Ubi lex non distinguit, nec nos distinguere debemus. Thus, the constitutional safeguard and obligation of the state to protect marriage extends to all kinds of marriages, and passing a divorce law by the state will violate its solemn duty. Jurisprudence is clear that the text of the Constitution is controlling, regardless of any constitutional commissioner's recorded discourse. Again, application is the rule, construction is the exception. Now let us assume constitutional interpretation or construction is the applicable method. Let us invoke, like many of divorce proponents do, the questioning of Father Bernas to Commissioner Gascon, and let us see if, assuming arguendo, the intention rule applies. Can we go to the slides, please? Next slide, please. Okay. Here, the Gascon-Bernas exchange is irrelevant when one considers that at the time Commissioner Bernas interpellated Commissioner Gascon, the word inviolable was not yet part of the proposed draft on marriage. In other words, Commissioner Gascon answered the way he did according to the state of the draft, as it was written on that day. This exchange occurred on September 24, 1986. If I may read the exchange. Father Bernas, just one question, and I am not sure if it has been categorically answered. I refer specifically to the proposal of Commissioner Gascon. Is it to be understood a prohibition of a general law on divorce? His intention is to make this a prohibition that the legislature cannot legislate a divorce law. Mr. Gascon said, Mr. Presiding Officer, that was not primarily my intention. My intention was primarily to encourage the social institution of marriage, but not necessarily discourage divorce. But now that he mentioned the discourse of divorce, my personal opinion, according to Commissioner Gascon, is to discourage it, Mr. Speaker. Father Bernas said, no, my question is more categorical. Does this carry the meaning of prohibiting a divorce law? Mr. Gascon answered, no, Presiding Officer. However, on the following day, September 25, next slide, please. Commissioner Regalado Maambong made a proposal to add the word inviolable to the draft. Mr. Maambong said, if I may quote, may I introduce an amendment after marriage? We say marriage, as inviolable social institution, is the foundation of the family and shall be protected by the state. I am introducing this amendment to realign it again with Article 52 of the new code, which says that marriage is not a mere contract, but a social institution. Then the voting happened. The presiding officer said, is the body ready to vote? As many as are in favor or the amendment as amended, please raise their hand. Everybody raised their hand, including Father Bernas himself. The Maambong Amendment was voted for by the commissioners unanimously. Thus, it was only at that point when the 1986 Constitutional Commission declared the intention to keep marriage as an unbreakable social institution. The additional word inviolable, which was used as an adjective of the word marriage, was accepted by the subject committee without question, unquestioned, even by Father Bernas himself. Thus, the amendment was accepted without any negative vote. To emphasize, Article 52 of the Civil Code and later in Article 1 of the Family Code speak of marriage as an inviolable social institution. In fact, the Civil Code was passed with the premise that there is no absolute divorce under the Civil Code and was later on embodied in the Family Code. Thus, logically, the constitutional commissioners, contrary to the misleading Bernas-Gascon exchange, did in fact intend to retain the status quo with the Constitution in mind, that is, that absolute divorce is prohibited. It is unconstitutional. Finally, the framers voted for and without any objection made on the present wordings of Article 15, Section 2, that it affirms that continuing prohibition of marriage based on its simple and clear reading. When the words of the law are clear, there is only room for application. Thank you and have a pleasant morning.
Thank you, Professor Calleja. Finally, our last speaker before we proceed to the panel discussion is my colleague from the Ateneo Law School, Attorney Patricia Anne de Santa Maria. Please welcome, Patty.
Good morning, everyone. Before anything, I would like to say how honored I am to stand here amongst obviously very distinguished co-panelists. I am usually a very nervous person, so I don't dream of public speaking in the slightest. But now that I am here, it is my pleasure to do so with very distinguished co-panelists. So thank you to the Justice Malcolm Memorial Foundation and the partners for the invitation. As you may have heard, I'm from that other school in Rockwell, so however much or little you expect of me, I do hope I live up to at least that. Incidentally, I did learn Consti 1 and 2 from Father Bernas, and it was his birthday, I think 2 days ago. So I'm sure he's up in heaven, delighted that he is once again the source of much discord and disruption. Okay. So I'd like to structure my remarks around two main lines of inquiry. The first is divorce and the Constitution, and whether we should treat the question of divorce as a constitutional question. I begin here because I think there is a danger when we make constitutions say things they do not, or adhere to some constitutional or legal absolutes when the reality is something else entirely. The second is divorce as remedy and policy. And there I'd like to go into why I think we should pass the divorce law and why I believe it is not an enemy of the family, nor of marriage. So is divorce a constitutional question? Or in other words, given what we know about our Constitution, how do we position divorce in a legal discourse? Our Constitution takes lessons from the past, but also looks towards the future. It is as much about aspirations as it is about the rules we memorize in class. In tackling divorce and asking whether it is a right or if it can be legally done, we have to refrain from being overzealous with constitutional superiority. Yes, the Constitution is the fundamental law. Nothing can rise above it. But a Constitution does not deal with everything. It does not dictate every exact rule or policy the country lives by, and we have to refrain from insisting that it does. As I previously mentioned, our Constitution is part aspirational, meaning it has left things to be done by those who will come after. It creates the space for democratic processes, however messy they may be, through which we, the Filipino people, discover for ourselves what we value and how we want to shape our country and our laws. We do the Constitution a disservice if we reject the opportunities it gives us for genuine lawmaking and community building in favor of an abbreviated inquiry which ends at whether something is constitutional or not. Now, going back to divorce, the question then is, does the Constitution give us rules or say anything about divorce? My position is that it neither prohibits nor mandates divorce. It says things about ideas we associate with divorce, depending on where we're coming from: marriage, family, religion, equality, children, so on and so forth. But divorce directly, not so much. There is no constitutional prohibition on divorce, and nothing in the Constitution is inherently contradictory to the idea of a divorce law. Now, of course, this is different from when the specific provisions now of a divorce law that will eventually come to be, whether those are constitutional or not. But just the idea of a divorce law, I believe, is not inherently contradictory. So what about family and marriage? So the big inquiry here is now how we treat Section 2 of Article 15, which, as you all know by now after 3 speakers, says that marriage as an inviolable and social institution is the foundation of the family and shall be protected by the state. So after today, you will dream of this provision in your sleep. The Constitution here upholds an ideal, a thriving family, and at its core, a strong marriage. Can we take this as a prohibition on divorce or a call to uphold marriage at all costs? No. It is true that we should protect marriages, but protecting is not the same as treating them as untouchable. Our own laws reflect this. There are already a multitude of ways marriages end under our laws. What I hope we take away from Article 15 is that our Constitution values the family. The marriages we must protect are those that nurture and enrich the family. Give it a solid foundation. If then a marriage does not, if it becomes harmful to the family, why not allow people to end those marriages? If a divorce can help a family, it should be made available. What of inviolability? And again, you will dream of this word by the end of today. Inviolability is interesting because it is not itself the command in Section 2, unlike when the word is used in other instances in the Constitution. The command in Section 2 is to protect marriage. But even if we don't get into it with how you word the Constitution, etc., just taking from how we treat other similarly inviolable things in the Constitution, inviolability is a principle we adhere to. It does not mean, however, that the policies, the accommodations, and the laws we create to address the lived experience of Filipinos contradict inviolability. We can respect the inviolability of marriage as an ideal while also providing remedies for the people who are navigating the realities of irreparable ones. We can hope marriages in general last lifetimes, but also recognize that some will not. These are not incompatible positions. So I now go to divorce as policy and why I think it would be beneficial for the country to have divorce. I was reading the House bill the other day and was pleasantly surprised to see it describes itself as a pro-woman legislation. And as an aside, I've been raised to think that pro-woman is how we should describe everything. No, all of us. This is good because it is something that needs to be said. The reality is that majority of those at the receiving end of domestic abuse are women, and it is these women who will greatly benefit from a divorce law. The ability to leave and cut ties with a violent, unfaithful, or grossly negligent spouse is a remedy which we should afford everyone, especially women who are often the disadvantaged party in the dynamic. I would go so far as to say the law should make it easy to do this. Divorce answers that need. Even when the actuations of a couple do not cross the line of criminality, consider what life is like when there is a grave incompatibility or constant discord between spouses. Can we honestly say that the environment that creates is compatible with the safety and happiness of parents and children? Now, mga Pinoy tayo, no? So a lot of us have opinions about how far couples can go, how you can work things out, what marriages can or cannot get past. But in all likelihood, only the people in that family will truly know what is right for them. Why deprive them of the choice to end the marriage if they know it is what will help them? We do not need to excessively dictate on the most intimate and private of decisions which adults who have entered into marriage are fully capable of making and should have the right to make. In fact, I would argue that given the proper safeguards, divorce facilitates other rights we do have. Our rights to liberty, bodily autonomy, decisional privacy, safety and security, and even the right to raise families in accordance with our beliefs. In the proper situations, divorce, while initially painful and disruptive, can be life-giving. It is not anathema to our individual rights, nor our integrity as a community. I end these initial remarks by saying that we do not put fire exits in buildings in hopes that the building will burn down. Similarly, we do not legislate divorce wanting for marriages to fail. What we do want is to give people another chance and to recognize that some people make mistakes. Some cases, some people are the mistakes. No? People change. They can change throughout their lives, even after marriage, and maybe not for the better. We cannot trap people in burning rooms, hoping to admire an undisturbed facade from the outside. We cannot uphold detached ideas of marriage and inviolability at the expense of the people who live and breathe and in some cases bleed in these marriages. Divorce is not the enemy of the family nor of marriages. The things that destroy marriage exist whether or not we pass this law. Divorce is instead a remedy and a chance for families to save themselves from the worst effects of these very same things. Thank you.